Well, hello students and welcome to the week 10 lecture for LW305 for 2024. This week we're looking at international and comparative law approaches to strengthening law. But before we do that, what I want to do is just do a little bit of a recap of what we've been looking at so far to hopefully find the narrative which perhaps resonates with you or helps you to understand how all of the different concepts we've looked at in this course fit together. Also this week there should be an overview of the readings, which will be very, very useful to you. And by this point in the course, I can surely recommend materials that have been uploaded to Moodle and are available looking at your individual assignment and the expectations, the assessment structure, and so on. Okay, so laws may not work for many reasons, right? They may not be locally relevant and appropriate. There may be resource constraints within the responsible ministries for implementing and maintaining and enforcing the law. The roads authority, do they have enough resources to keep the roads well maintained? Do fishing licensing and enforcement authorities have the resources to completely prevent illegal fishing? Okay? So there's lots of reasons. Understanding what I'm terming here the operational paradigm can inform strategies to strengthen the law. What do I mean by operational paradigm? Well, the paradigm of something is simply the way things are. And that might be very complex. If we look at the way Fiji society is today, there's a political paradigm which influences that overall paradigm of how the place is today. There is a cultural, historical, economic, etc. All these different aspects or their own paradigms, the way those things are, which have histories and have changed over time and have interacted at different times, have been impacted by colonialism, by wars, by coups, etc. All of these things coalesce and come together, and they create the paradigm of things. So we can look at a paradigm at that all of the country level, or we can look at those components. Well, what is the paradigm of politics? What is the paradigm of political parties? What is the paradigm for individual politicians? What is the paradigm for political election in an outer island province? Is it different from election in a urban place like Suva or Honiara or Port Vila? How are these things? And I'm saying that the operational paradigm here is where the law operates. So laws might not achieve their stated purposes for lots of reasons, but if we can understand the place, the context, the culture, the environment, and the point in time in which, because there are these long changes over time of different values, from immorality to morality shifts over time, from liberty to autocracy changes over time. So there are these long temporal arcs that weave throughout history, affected by all sorts of things beyond our control, but they help us describe where we are now and understand the constraints, our options, if it's law reform, our options for reform. And our capacities and strategies must be informed by the limitations of our options, by our constraints. So if we understand how laws operate and the environments in which they operate, how they are designed or intended to operate, and study that, then we can develop effective strategies to strengthen that law. It stands to reason that that understanding would lead us to insights into how those things change, or how we would like them to change. In week 8, we discussed the importance of the idea of legitimacy to strong laws. If people don't view law as legitimate, it will be weaker. We also discussed ways of strengthening legitimacy of law through things such as communicative action, by leveraging traditional and charismatic authority, and other methods for strengthening laws and strengthening legitimacy of law. And we looked at other concepts that were important. Week 9 focused on strengthening law using proven strategies and techniques. We looked at different models, different ideas. We said that, well, a lot of law isn't about the written law, it's about behavior of people. Law has very little to do with behavior of people. I mean, yes, knowing that something is prohibited is a source of influence on me, but if I'm 17 years old and all of my friends are drinking beer, I might not care what the law says. I might just drink beer. Plus my parents said it was okay. Who cares what the law says? Well, the law says your parent can let you drink if you're above a certain age. What if you're only 12? That would be terrible, wouldn't it? What's a 12-year-old know about law? What's going to influence a 12-year-old to obey the law when they're below the age of what we deem mental capacity to understand law? Well, so how do you make a child comply? Well, we looked at that. We looked at what motivates people. Perhaps they're more motivated by fear of punishment and discipline, like a child. And adults, I don't want to go to jail. And we looked at some of those other motivators. People might be motivated to be good citizens. People might be motivated by appealing to rationality if you give them a good argument. We used the example of seatbelts to demonstrate how different people with a different basis for moral decision making regarding wearing seatbelts might be encouraged to wear seatbelts using different strategies that target these underlying motivations. We looked at the fact that you can use that knowledge to then match approaches to changing behavior to the types of influence that the regulated feel. There's a missing word in that slide. Our readings from this week expand our understanding of how to strengthen law to include theories of compliance, theories of motivational posturing, and ideas of responsive regulation, to see how a responsive regulator can use this knowledge of motivation and compliance and use this understanding gained about the place we're in, the paradigm in which the law or the regulation or the regulator must operate, and use that knowledge to respond to what it actually encounters, to enable it to influence, to enable it to improve, say, legal professional standards, if it's a responsive legal profession regulator. Also, this week, we're looking at still, I guess, a mix of theoretical and practical matters, but into something which might feel a lot more familiar and comfortable to a lawyer, comparing law. And particularly it should be familiar to USP students, because you don't understand perhaps how unique it is that every single substantive law course that you do is taught comparatively. It's taught by an instructor who is familiar with different laws in different places, who is familiar with the histories and the social context and the economic global security paradigm of the Pacific. And you are taught to understand the law of your place through extensive reference of the law of different places, which imbues you with an automatic understanding that there are different ways of doing things. And those different ways of doing things have evolved because different places have different starting positions. We'll come to that in a moment. In essence, comparative law is comparing laws here with laws there. Laws from this place with laws from that place. And it might not strictly just be laws. There's other elements to this. You could have comparative cultural studies, which still draws in this, culture as is tightly related to norms. Culture and norms are performed in society. Societies are governed by bureaucratic norms and rules. And so in that way, you can see that custom, culture, law, and their study are sort of all bound up. They're a bit inseparable. You can't just look at law without looking at society. If you want to understand what the law is, what's going on, and how it works. And we know that a frequent failure in the region is the transplanting of laws. This is sort of the neo-colonialism era, but the pre-colonial era. And we'll look at one of the readings this week looks quite closely at this matter. The transplant of laws from one place to another place where the circumstances the laws must apply to are vastly different, can be problematic. And it often arises from a misuse of comparative law, the idea that we'll modernize the deficient laws here. So obviously the laws here don't work because they're 60 years old and they came from England. But what we should do is take the laws from New Zealand or Australia and just copy and paste them into our laws. Boom. Boom. Comparative law done. Fixed it. I fixed the Fiji Tax Act. I fixed the Fiji Criminal Code. I fixed the legal profession, or the Legal Practitioners Decree Act, whatever. Well, no, obviously it's not just about copying and pasting, and it's not just about, carefully trimming away things that don't apply. There are some significant issues in Fiji's criminal law that arise from the way the definitions of certain offences or elements of offences were transplanted. But this is not criminal law. And so a real problem with it is that legitimacy of law, for the people to view the law as legitimate and applicable to them, still requires autochthony. It requires local generation. It requires local buy-in. It requires local consultation. Sure, you can look at what they do elsewhere and maybe use it to generate options. We'll talk about that. But you still need to present those options to the people. You still need to have a vehicle for this place to collectively have generated the laws of this place. Otherwise, the law lacks legitimacy, which has all sorts of flow-on effects in terms of compliance. Okay, so a further warning with this, with comparative law. Just think for a second that, there's a number of ways you would use comparative law. Judges, well, let's start with judges. Judges make law. When a judge looks to judicial decisions in other countries, what are they looking for? It's not binding, right? We know it's persuasive. Why is it persuasive? It might not be persuasive at all. But what the judge is seeking, and what counsel should be submitting to the court, is for a potentially persuasive decision by a reputable foreign court. What does all that mean? Well, usually it means it's a fairly recent decision, and if it's not recent, then it should be really, 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 really groundbreakingly significant. It should be from a reputable source, right? It should be from the highest court of a foreign country. The Fiji Court of Appeal won't really listen to the New South Wales Magistrates Court. Who cares what they think? And there should be a similar paradigm. We should be dealing with the similar facts or similar circumstances or things which are analogous in some way. Yeah? And then if we can get that sort of context right and that, that legitimacy of authority right, then perhaps we're on the right path in comparing things. So let's flip that and have a look at law or legislation. So when comparing two laws, you or a lawmaker might look to a recently reviewed, reformed, or revised law in another country. If it was revised 45 years ago and you're looking at all the stuff that happened then, well, the social context, the paradigm then, compared to the paradigm now in that country, let alone our country, are just like Earth and Mars, completely different. Different time, different place, different people, etc. There might be useful elements from the report. The process might still be valid if it was a really robust process, but the methods might not. They didn't use computers then. Maybe you do consultations here in different ways. Anyway, we're getting a little bit far-fetched. Or rather, beyond where we need to be. Not far-fetched, very real. You might look to reforms in a similar or a neighbouring country. And it might make sense to look to Australia and New Zealand. Rolls-Royce law reform commissions, lots of really qualified, skilled people fighting out and fighting for the right opinion in law reform reports and committee reviews and all the rest of it. So it's a robust process. And even if you disagree with what is produced, the scope of opinions or perhaps the options generated might be worth looking at. So you can shortcut. You don't have to reinvent the wheel. You don't have to come up with your own options to put to the people. You can look at other options, think about how they might work out here, maybe adjust them slightly as an idea, and then consult on that to try to figure out where the problems are. You might want to make sure wherever you are looking to that the reform process and any outcomes satisfy principles of good law reform. Communicative action, consultation, public debate, parliamentary debate. Looking at you, Fiji, again, looking at you. Reports from a foreign law reform commission, as I said, very, very significant and important. And Samoa's got now a very capable law reform commission, Vanuatu has a new one. Fiji's lapsed and languished years ago between coups in the early 2000s, and to Fiji's great detriment, it's never been restarted, which is just dreadful. So what's something else that's worth saying here? Well, I've got all this stuff about Rawls and context on the screen. We've talked about John Rawls in a previous lecture earlier on in the semester, and I linked you, I think, to the same podcast on social justice and his idea of the original position. So I just wanted to briefly expand on the idea that context is critical when comparing law. According to Rawls, laws should seek to achieve justice. What do you think? Do you think, yep, every single law should seek to achieve justice? Can you think of any exceptions, any laws which should be unjust? Neither can I. So Rawls might be onto something here. Certain sort of universalities that he's trying to get at. What we want in society, if we want to live in a nice place, is all laws to be just. Well, what does that mean? Well, for Rawls, that means, one, each person has an equal right to a fully adequate scheme of equal basic liberties, which is compatible with a similar scheme of liberties for all. So, equal opportunity, equal social liberty. First. Second, and secondary to that principle, social and economic inequalities are acceptable. It's acceptable for there to be inequality in society. Only where they are natural. If they are unnatural, like I inherited $1 billion and then sat on my butt jet skiing all year round, that would be an example of unnatural inequality. If that billionaire was then investing in business, environmental schemes, not polluting the earth, trying to develop great new technology for the future of humanity, etc., well, then we might start going in the direction of saying, well, look, yes, that person has $1 billion and it's sort of nobody should have $1 billion, but what they're doing with that is for the betterment of humanity. Kobe Bryant is earning 70, 80, 100 million US dollars a year more, but why? Just because he was born with this God-given talent, his natural abilities. Well, yes, and you know what? He trained hard and worked hard, and people around him worked hard. And you know what? He entertains millions every week. And in that sense, we can say, well, even if we think that the salary sports stars get paid is gross and unnatural and unjust, when we see someone using their natural abilities to their best possible purpose, we start to think, well, they've earned that. It's okay. It is just. Rawls says that justice is achieved when social and economic policies are distributed according to the following principles. Government has limited resources. We know this. When we want to distribute the limited capacity of government to support society, we must firstly adhere to the rule that the greatest benefit in society should go to the least advantaged, regardless of how wretched and undeserving. That criminal who murdered has a horrific circumstance. And it is just to direct benefit to that person. It is just and appropriate to direct the resources of society to rehabilitation and reform. This is a lost person. They've done horrendous things. Yes, of course, the victims and survivors of that person's violence are also terribly disadvantaged, and we should be directing huge benefit to them. They may be more wretched and for their own reasons more undeserving of support than the perpetrator. Who knows? But it is just to put on a blindfold and treat the need in front of you. This is a damaged person that needs support. Support them. Pretty hard to do, isn't it? What about that boyfriend or girlfriend that cheated on you, huh? You reckon you could just treat them with great benefit and equanimity? But this is a principle of justice. It's an ideal to achieve. Public offices and positions are open to all under conditions of fair equality of opportunity. So justice is achieved when civil society is governed by directing the greatest benefit to the least advantaged and through equal opportunity of access to public office. Rawls also was a strong believer in procedural fairness, right? That the rules must operate in a fair way. For Rawls, social policies, laws and practices which are not structured in accordance with these principles are unjust. What did we say before? All laws should be just. Justice should be achieved through every law. So, if laws, to Rawls, don't direct the greatest benefit to the least advantage, don't create equal opportunity and access, are not procedurally fair, then they are unjust laws. Period. They are detrimental to society in their current form by virtue of being unjust. It is okay for there to be inequality, but not injustice. So consider such things as resource contexts, public funds and human resources, institutional contexts. How do you enforce laws? Geography, the size of different places, variations in philosophical orientation of different places, different provinces, different countries. Connecting this back to comparative law. Geography, size, institutions, resources, philosophical orientations. What a different society considers to be justice might affect how useful your comparison is when you're comparing the laws of that place to the laws of this place. When you're developing options or strategies for strengthening law here based on what you have learned or read online or wherever about there. So your readings this week talk a bit more about doing comparisons, but what are some ways of doing it? How can you use comparative law? Well, I alluded to it earlier. A great way is to have a look at how statutory provisions are drafted elsewhere in a recently reformed, reviewed, revised, whatever place. Ideally, because you know it's been looked at recently. Or a report that a law reform commission or a parliamentary committee or whatever has made. And from those you could gather options or generate options for reform. You can say, well, one option is this. Another option is that, and a third option is this. And you can then seek public input into those options, or whether there's an additional option that, hasn't been put to the public. And that's a very, well, it's an easier way. It's also a fairly robust way of generating public debate. Because if you give me something to read, to go, okay, well, these are the options. Okay, you've looked at what Australia and New Zealand did. Okay, and Vanuatu recently reformed its financial services laws or whatever. Okay, so you're saying that, well, these are the options that were generated in Australia and New Zealand. Okay, this is sort of the options that were generated in Vanuatu. And which of those approaches do I think might be good here? And I can now give my opinion, my submission, discuss how each option might affect my stakeholders if I'm an organization or a business council, and put that in my submission, right? I can use comparative law that way. You could also use it to justify an option, saying, well, this is the best option. The way that Australia redrafted its Marriage Act is the right option. Or a criminal provision. Mandatory vaccination. Well, UK did it, and America did it, and Indonesia did it, and Australia did it, and actually everyone's doing it. So, we'd be the odd ones out if we didn't make vaccination mandatory. In fact, it would cripple our entire tourist industry and economy, because our workers can't get out or in, and we go bankrupt. Sentencing laws. Death penalty. Looking at you, PNG. Jeez. Why'd you drag that one back up? Why did you drag that one back up? Anti-doping regulations. Fiji's got international athletes. Those athletes have mandatory reporting. They have to say where they are in every 24-hour period. They have to report every time they donate blood. They have to report all of these things to central authorities. That's not because the Fiji government or the Fiji doping authority hates them. It's because they want to be a member of an international body, which has this whole set of requirements. And it requires each country to comply with those requirements. And so we can justify the harsh rules we're taking here, or the very strict rules and approaches we might take here in a particular country, because we're a signatory to CEDAW, because we're a signatory to a convention, because this institution is part of this international institution and must adhere to its rules to maintain accreditation, etc. That's a good way of using comparisons. You can use them to do an impact analysis focused on the local context. So we can look at laws elsewhere and say, well, okay, if we put that in place here, those specific things, if we did that and made it here, what will be the impact? How will industry respond? How will individuals respond? How will our regulatory authorities respond? And by going through that process, you can start to anticipate tensions or challenges for implementing a law that looked like the one that you were looking at, that foreign one. You might then consider how you adjust or tweak it, redraft it, innovate, so that you can design better laws, and so that you can establish your regulatory system to operate in a more responsive way. And that's the end of the week 10 lecture